Welcome to this module, Common Q&A, which is part of our Library Law Core Endorsement course for the State Library of Iowa. My name is Mary Ann Morey, and I'm District Consultant for the Central District with the State Library of Iowa.
And I'm Mandy Easter, Law Librarian with the State Law Library of Iowa and a State Library Consultant.
Although we have three objectives for this module, we won't look at these separately. Rather, the objectives are more of a whole thought to the entire module. At the conclusion of this module, you should be able to recognize 5 aspects of public library management that present legal concerns. You should also be able to describe how state and federal laws, as well as court decisions, affect the library's policies and procedures. And finally, you'll be able to identify 3 reliable sources of legal information and guidance regarding the liabilities of public library management. We've shared this resource in our other modules, but we can't point to it often enough. Mandy has done a phenomenal job of providing a variety of legal FAQs that she has researched and posted on our website. Follow the breadcrumb trail at the top of the screenshot to locate this page of our website. Click on the blue Link to Online Searchable Databases to view and search for information to answer your library's legal questions. Some of the Q&A we'll be discussing in this module are taken from this resource, which is simply a list of commonly asked library-related legal questions we receive from librarians. We'll only have time in this module to focus on 5 questions, but these are ones that seem to arise over and over on a regular basis. We'll present them in no particular order. Some of these questions we have discussed, at least in part, in previous modules, but review is always good. And as we said at the beginning, these are topics of questions that we receive repeatedly, so it never hurts to readdress these topics. Our questions for this module include aspects of records retention, book sales, banning of patrons, changing your library ordinance, and copyright. Here's our first topic, records retention. It seems that many new library employees feel themselves overwhelmed with the vast amount of files at the library. What do I have to keep? How long do I have to keep it? And where do I store it? These are questions we often field from new library employees, whether it's youth services staff wondering how long they're supposed to keep old summer reading materials, or new directors wondering how long they have to keep boxes stuffed with old receipts. The questions usually stem around the fact that the library only has so much space and can't possibly continue holding on to all this paperwork indefinitely. While your predecessor may indeed have had pack rat tendencies, there may have been good reasons why all those records were saved. But likewise, it may be that many of the old files no longer need to be retained. How do you know the difference? A few years ago, Mandy and I gave a presentation on this very topic of records retention. This session is still available in Iowa Learns as an archived class. It goes into great detail about what needs to be kept and for how long. We recommend you view this full archive recording for the best information on this topic, since we'll only be doing a quick overview in this module. In that session I just mentioned, Mandy and I cover 5 steps of record management. Mandy will provide us with a quick rundown of these steps.
Step 1 is conduct an inventory. To begin, a library must find out what records it has stored, not only in active office space, but also in the basement, the vault, on computers, mobile devices, servers, or any other place where inactive records have been stashed over the years. Step 2, appraise the records. After the inventory is complete, the types of inventory should be sorted so that each category of records can be classified and its value appraised in preparation for the next step, deciding how long to keep each type of record. This step may involve research into requirements set by law or auditing standards. Step 3, schedule the records. After the classification and evaluation of records in the appraisal process, a decision is made regarding how long to keep each record series. This information is compiled into a record series retention and disposition schedule that names a record series and states its retention period, usually in columns. Step 4, organize the records. Using the information gathered in the inventory process and decisions made in the appraisal and scheduling steps, Library staff can now roll up their sleeves and physically organize the library's records. At this time, files should be weeded of valueless paper, and non-current records should be removed for storage to inactive areas. Step 5, implement the program. Once the organizational phase of the program is completed, you might be tempted to consider the job done. Certain steps in the process, however, need to be repeated regularly in order to establish a records management program rather than a one-time house cleaning.
A lot of those steps may not mean much without benefit of the full archived webinar, so we strongly encourage you to view it and talk with your district consultant. Realize that some records, such as your board meeting minutes and reports submitted to the state library, should be retained indefinitely. Other records, such as your daily or monthly tally sheets of library user information, should be disposed of after those numbers are calculated on a master report. Some records may surprise you. For instance, summer reading materials provided by the Collaborative Summer Learning Program, or CSLP, expire after the summer reading program for which they're specifically designed and are illegal to use after that. But employee personnel files need to be retained for 60 years. This is why it is important to know what you're supposed to save and what you're supposed to destroy. Don't just start tossing files without knowledge of what they are and their importance. In that archive reliable records retention session, we also give you some good tips about what to do with paperwork once you determine its relevancy and retention rate. In most all circumstances, you'll either file it for immediate use, store it for retention purposes, or destroy it. Electronic files should be treated in the same manner.
It's also important to understand which electronic records, signatures, and contracts are legal and how they can replace paper records. We're often asked whether or not libraries should retain paper library card applications, computer use sign-up sheets, meeting room reservation agreements, or interlibrary loan and reference worksheets. It's interesting to note that in some circumstances, it can actually create legal liability to store paper records. For instance, retaining paper library card applications isn't exactly illegal, but the practice does create legal liabilities. Library boards and directors are legally obligated to regularly protect their patrons' personally identifiable information and the confidentiality of their library transactions. Electronically encrypting and shredding paper files is often preferable to physically storing them. Even making paper files available for volunteers to rifle through is dangerous, let alone the havoc a rogue or disgruntled employee can create with them. There are resources available to assist you with your records retention review. First of all, find out whether or not your city already has records retention policies, procedures, and practices, including predetermined schedules. If it does, you should follow them. If there doesn't seem to be a citywide program in place and you're apparently on your own, you can download and print the manual you see on the screen, which was produced by the Iowa League of Cities and is fairly comprehensive. Watch the archived webinar we mentioned and contact our offices with questions.
This next question is asked often, too often, considering how many times we have addressed it in training sessions and library forums. The question is, how can I get rid of withdrawn or weeded books? You've seen us reference this piece of Iowa law several times now, and it bears repeating for this situation.
Article 3, Section 31 of the Constitution of Iowa comes into play regarding book sales. It says in part that no public money or property shall be appropriated for private purposes. Public officials must exercise control over any public funds and public property in their charge. Iowa's Attorney General, as well as our courts, determined that there is no way to effectively control funds and property once they leave the public agency to which they've been appropriated. When the library acquires materials, including the moment a staff member accepts a book donated to the library, they become public property, subject to myriad legal restrictions regarding their disposition.
This section of the Constitution means you cannot give away your withdrawn or donated library materials, furniture, or electronics to private entities such as Goodwill, Planned Parenthood, local private daycares, individuals, and even your Friends of the Library organization.
Iowa Code Section 256.51, subsection 1L, says that the state library shall allow a public library to dispose of, through sale, conveyance, or exchange, any library materials that may be obsolete or worn out, or that may no longer be needed or appropriate to the library's mission. These materials may be sold by the library directly, or the governing body of the public library may sell the materials by consignment to a public agency or to a private agency organized to raise funds solely for support for the public library. Proceeds from the sale of the library materials may then be remitted to the public library and may be used by the library for the purchase of books and other library materials or equipment, or for the provision of library services. It is perfectly acceptable to recycle or throw away library materials that don't sell or are in poor shape. If you're worried about the public finding your dumpster full of books, dispose of them, the books, not the public, in black or opaque plastic garbage bags. It may be best to do this a few books at a time. If recycling is an option, it would be better to rip off the book's covers, throw those away, and then recycle the book's pages. Do not give books and materials to someone who offers to, quote, take them off your hands, unquote. At that point, you lose control of the public property in your charge. And depending upon what happens to these items, they may very well end up contributing to the profits of a private entity, which conflicts with the constitutional provision mentioned earlier, as well as Iowa Code Section 721.2, which makes it a crime for government employees to allow public property to be used for private purposes or gains. However, library property can legally be donated to other government agencies, whether they're at the city, county, state, or federal levels. Public schools are government agencies and will often accept items, such as used computers, for students to take apart in electronics classes. Likewise, Head Start programs are federal daycares, so you can donate children's books, toys, and puppets to them. These same concerns and concepts apply to getting rid of old electronics, equipment, furniture, and other real property. Ideally, your city has a policy or program for recycling or disposing of its own electronic trash and property. Check with the city clerk or the city manager. Alternatively, there is likely a surplus procedure by which city agencies must surplus all property no longer wanted or needed so that the city can remove it from its inventory and insurance rolls, and so that something shed by one city agency can perhaps be given to another city agency, even if it requires repair or reconditioning. The Iowa League of Cities writes on its website, quote, "There are no Code of Iowa provisions governing the sale of city-owned personal property such as vehicles, equipment, goods, or furnishings. Cities should dispose of such property in a manner calculated to obtain the best possible sales price. Cities typically achieve that result by requesting bids or by advertising the property for sale at a minimum price based on its market value, if any," unquote. So it's up to local governments to pass ordinances regulating the conveyance, transfer, or disposal of unwanted city property.
Here's another option for those withdrawn books. There are lots of repurposed books projects that could be turned into library programs, or as you see in the photos on the slide, you might be able to use those books as fun furniture in your library. Search online for projects, craft ideas, and programs revolving around old books. This chart summarizes the basics of what is okay versus not okay when it comes to handling the library's withdrawn items. Note that it is okay to sell withdrawn or donated library materials to your friends group so that they can resell them to the public, even if the price you charge the friends is nominal. It's common to offer the friends a box or bag of books for $1 or even less. However, it is not okay for the library to sponsor a book sale and then give the funds from the sale to the friends group. It's best and most convenient to train the public to donate items directly to the friends. A memorandum of understanding between the library and the Friends could include a provision that allows the library director the first right of refusal on all donations. Talk with your state library district consultant if you have questions about any of this. Our next question deals with banning patrons. We addressed this situation in our module about serving families. Hopefully, you will recall information from that class, but it never hurts to repeat information that we know our librarians request often. Can the library ban a patron? And if so, can the library ban someone for a very long time or permanently?
Federal courts have repeatedly ruled that city residents have a First Amendment constitutional right to use their public libraries, which are supported with their tax dollars. So decisions to ban residents from their public libraries should not be taken lightly. I find no evidence that any public libraries are issuing lifetime bans, so those are likely legally problematic and not recommended. Typically, libraries' maximum bans are 1 or rarely 2 years, with most finding that 1-day to 3-month bans are most effective. The majority of public libraries have ethical issues with banning juveniles for longer than a month, no matter what they've done. And most find workarounds, such as allowing the child to come into the library during the ban if he comes with a parent or guardian. Many libraries include a statement in the ban notification letter indicating that the patron may continue to use his public library by sending a designated surrogate to the library with his library card and a list of materials wanted or needed. Federal courts have ruled in favor of public library conduct policies that meet the following conditions. 1, the policy is written to include specific behaviors that are particularly egregious and will result in being banned from the library. Note that the length of time banned does not have to be specified in the policy and can be determined on a case-by-case basis. And generalized statements relating to conduct are legally problematic. 2, the behavior guidelines must be considered reasonable to the average person. 3, the guidelines cannot be arbitrary or discriminatory. They should not target a legally protected class of people, even inadvertently. 4, the banning process must be progressive unless the behavior presents an immediate and profound threat to other patrons and/or staff. Violent or clearly criminal acts have been cited as acceptable reasons to forego progressive discipline. 5, fair notice must be given to both adult patrons and parents of minor patrons in the form of registered letters of warning, preferably 2 or 3 of them, detailing the conduct policies being violated, documenting the date or dates on which the violations occurred, and stating the consequence if violations continue before a ban is instituted. And 6, there must be an appeal process in place. The Board of Trustees hears appeals, through which the ban can be reduced or vacated, and the patron must be notified in writing of the procedure to follow. Sample policy language regarding appeals can be found in my library law FAQ on bans. Finally, please note that a library's director or the manager on duty is the person who makes the decision to ban a patron and for how long. The director should not bring the matter to the board to decide. It is not the trustee's decision in the first place, and letting them decide violates the patron's legally protected library confidentiality. The board sets the banning policy and hears any appeals of the library director's decisions. It cannot hear an appeal if the trustees participated in the original decision.
Here's a sample of a behavior or conduct policy from a larger library in the metro area. Your library's conduct/behavior policy is likely the most appropriate place to include aspects of banning. You can see that this policy meets the criteria Mandy mentioned in our previous slide. It's non-discriminatory because it is based upon behavior rather than appearance or age or any other distinguishing characteristics. It mentions specific behaviors and notes that additional behaviors are spelled out elsewhere, and the reasonable expectations are also noted. It's fair notice. I am assuming this policy is displayed in the library. There is an appeal process in place, And there is a progression of expulsion noted, increasing from 1 day to 1 month for minor violations or up to 1 year for major violations. Here's our next category of legal questions. I dare say that several times a month we are asked questions related to changing the library's ordinance. You can see on the slide some of the types of questions we receive regarding this issue. If you will recall from other modules in this course, the city's library ordinance is unique. Although the City Council established the ordinance, the City Council cannot change or revoke the library's ordinance. This is a unique fact since all of the other city ordinances can be changed by the City Council. If you will recall from a previous module, an extremely important aspect of Iowa Code Section 392 is this highlighted subsection, which I'll allow Mandy to read for us.
It says a proposal to alter the composition, manner of selection, or charge of a library board or to replace it with an alternate form of administrative agency is subject to the approval of the voters of the city. This is state law affecting every single public library in Iowa. What this means is that your library's ordinance, which is the legal document that states the composition, manner of selection, and charge or duties of your library board, cannot be changed by anyone other than the voters of your city. Your city council cannot change it. Your library board cannot change it. Your city clerk cannot change it. And your library director cannot change it. The library ordinance, unlike other city ordinances, cannot be changed by anyone other than the voters of your city. Section 392.5 goes on to say, the proposal may be submitted to the voters at any city election by the council on its own motion. Upon receipt of a valid petition as defined in Section 362.4, requesting that a proposal be submitted to the voters, the council shall submit the proposal at the next regular city election. A proposal submitted to the voters must describe with reasonable detail the action proposed. If a majority of those voting approves the proposal, the city may proceed as proposed. If a majority of those voting does not approve the proposal, the same or a similar proposal may not be submitted to the voters of the city for at least 4 years from the date of the election at which the proposal was defeated.
Many of the questions pertaining to your board, such as how many trustees you should have or whether you can have a teen serving as a trustee, will be answered by looking at your library's ordinance. That's where you'll learn the proper selection and appointments, how many trustees should be on your board, the residency and age requirements of those trustees, terms of service, although in some cases the terms of service are outlined in the library's bylaws, and the duties of your board. You can see what we mean by looking at Iowa's Model Library Ordinance. This template, ensconced in state law until 1973, contains wording common to almost all of Iowa's public library ordinances. Be sure you have thoroughly read your library's ordinance and that your trustees have done likewise. Then realize, as we said, that only the voters of your city can change these aspects of your ordinance. Contact your district consultant to learn more about the legal process of changing a library ordinance. Copyright issues often come rather innocuously, such as the situation posed by this librarian's question. Whenever a patron comes in with photos, recipes, or magazine articles to photocopy or scan, I never know if I'm breaking copyright law by duplicating them. How do I know? Is the library exempt from copyright laws?
Because of the enormous legal liability involved with copyright, librarians should never be the actual operators of their library's photocopiers or scanners for patrons, since the person who pushes the button is the person who gets prosecuted. Copyright attorneys advise that if you cannot figure out a way for patrons to do their own photocopying and scanning, don't offer the service. Even if staff members have to leave their assigned areas to use the public copier or scanner, that's far better than leaving the equipment in employee-only areas and doing the copying and scanning for the public. Copyright law is too complicated for librarians to be making multiple decisions every day about what is legal or illegal to photocopy and scan. Don't do it. If your patron wants to photocopy or scan a magazine article, your ignorance regarding the content of her actions is your protection from a lawsuit. Make her do it herself. Your patrons will probably appreciate the anonymity of confidential transactions anyway. Find a way to provide a photocopier and/or a scanner for patrons to use without staff assistance. Place a simple sign in a bold font on or very near the machine that reads, "Notice the copyright law of the United States, Title 17, U.S. Code, governs the making of photocopies or other reproductions of copyrighted material. The person using this equipment is liable for any infringement." If you can't or don't want to install a coin-operated attachment, proceed with the honor system and ask patrons to tell you how many pages they copied or scanned when they're done. Collect their money at the front desk.
But copyright issues often arise in our libraries where it is the responsibility of the director or the board to be aware and to make wise legal decisions. Copyright is a federal law, and libraries are subject to copyright laws, which may affect the kinds of programs you offer, your ability to read a story online, and even the way you choose to decorate the children's area of your library. We shared this information in our module about laws for libraries, but it bears repeating.
Libraries are potential copyright infringement minefields, so it cannot be overstated how important it is to be aware of our federal laws pertaining to copyright. The State Library can help you learn the meaning of legal phrases such as public domain, derivative works, fair use, educational exemptions, prior permission, terms of use, and others. Copyright laws affect many facets of librarianship. Besides knowing whether or not you can scan or copy materials for patrons or live stream a story time, you may need to assess the legality of posting pictures of book covers to social media, broadcasting high-interest television events in the library, converting VHS tapes in your collection to DVDs, incorporating YouTube or Netflix content into programming, creating parodies of popular songs for recorded promotions of library programming, publishing local pictorial or oral history projects on the library's website, and more. Plus, what can libraries do with the digital copy codes that come with the movies they buy on DVD? And what should you do if you receive a notice from your internet service provider threatening to cut off the library's internet connection because illegal activity has been detected on its account? The State Library provides answers to these and many other questions about copyright.
There's a fairly large section of our library law FAQ page pertaining to copyright. Read the questions and answers posted there, and then contact your state library district consultant or the state law library for additional information regarding your specific situation and copyright concerns. If you have legal questions or other library questions for that matter pertaining to your library, there are some readily available places for you to turn. The state library's consultants field lots of questions every day from library directors, staff, and trustees, as well as from city officials and individual citizens. Don't ever hesitate to use these consultants as your go-to resource for any library-related questions. Always check the Library Law FAQ page on our website, which you again see pictured here. Contact your state library district consultant if you need assistance navigating to this page, if you have follow-up questions, or want additional information of any kind. The state library is here to serve you and to provide you with reliable resources and the answers you need.
Finally, your city attorney can provide library directors and trustees with legal advice concerning any of these questions. Be aware that in most cities, agencies that use the city attorney's services will be charged an hourly fee of some type. In other municipalities, agencies cannot contact the city attorney without prior approval from the city administrator. In some cities, mainly larger ones, there are few, if any, restrictions on contacting the city attorney's office. Check with your city to learn the proper procedure for contacting the city attorney and ask about any agency fees for obtaining legal advice.
This concludes our final module in the library law course.